advent of AI is only a bonus for those experts who can use it well as a tool.
Do you feel AI can, maybe if not completely, but to some extent, replace what experts do today?
I think this has something to say about whether, from a purely technical perspective, the function of an expert witness could be done by an AI. That said, we work in a human system, and I do not believe that will change for a good number of years.
Hello and welcome to On the Stand with Ashish Arun, the podcast where we explore the law, practice and business of expert witness testimony. Today's guest embodies the rare combination of cutting-edge innovation and sophisticated litigation expertise. Dr. Daft brings over 3 decades of experience, from Oxford research labs to Silicon Valley boardrooms to high-stakes patent courtrooms. After earning his doctorate from Oxford and teaching at the University of Illinois, Dr. Daft spent a decade at GE's Corporate R&D Center, earning their highest technical honors for his contributions to ultrasound imaging. He went on to become a senior key expert at Siemens Healthcare, their highest technical designation, while also founding multiple medical device startups. Since establishing River Sonic Solutions in 2012, Dr. Daft has testified in 15 depositions and 5 trials across federal district courts, the ITC, and the Patent Trial and Appeal Board. His cases span landmark disputes from breast cancer imaging systems to the Masimo Apple Watch blood oxygen monitoring battle. What sets him apart is his dual role. He maintains active technical leadership as CTO of Sunmy Technologies, developing FDA-cleared transcranial ultrasound for mental health while building his expert witness practice. This keeps him at the absolute forefront of medical innovation while serving as a trusted voice in the courtroom. So today, we'll explore how expert witnesses bridge the gap between deep technical complexity and courtroom clarity, and what makes the difference between an expert who confuses and one who illuminates. So on that note, let's welcome Dr. Daft to the show. Dr. Daft, welcome to On the Stand.
Well, thank you so much, Ashish. I'm glad to be talking with you this morning.
Oh, the pleasure is all mine. So, you've had a remarkable journey from an Oxford physicist to Silicon Valley innovator and now an expert witness. So what initially drew you from pure technical work into the world of litigation support?
I think it was the pleasure I derived from teaching. I've always enjoyed teaching, like at the university level, and the best points when I'm in a trial or something is when the judge tells me that I have well illustrated the issues at stake so that they can understand, and that really makes it for me. So I think it's a teaching thing, basically.
Mm-hmm. And was there a specific case or moment that made you realize this was something you wanted to pursue seriously?
Oh, absolutely. I was on the stand at the International Trade Commission in Washington, D.C. Those cases at the ITC typically have very technically sophisticated judges. And so I had done my direct testimony in written format. I had the adversarial testimony, and then the judge decided that he wanted to question me. And basically, I was able to spend some time going through how the imaging system actually functioned. And I thought that was a really interesting way of earning a living. And so I was committed to the expert witness path after that.
But you've also intentionally maintained a 50-50 split between active technical work as CTO of Sunmy and expert witnessing. So do you think this balance is important, and how do you manage it practically?
I do think the balance is important because in depositions, the cross-examining attorney is often trying to get traction with the position that I am just some hired gun who doesn't do any technical work and is only interested in litigation. And so it's very helpful to point to the amount of time I'm spending doing pure technical work that has nothing to do with litigation. I also am responsible for patent filing in the company you mentioned, and so I can point to how I'm doing the patent prosecution as well as the patent litigation. So how to balance those is somewhat random, and I just have to take it as it comes. There are times when I have plenty of time to get everything completed, and there are times where I just have to work really, really hard because litigation has chaotic deadlines. It's really almost never the attorney's fault. You know, the court will change something and suddenly I have to produce really quickly. I feel like that some of the value that I provide to attorneys is flexibility in that I am willing to just work very hard at the points when that's necessary for their case.
Mm-hmm. And on the point of the hired gun allegation, that I think pretty much every expert who's been on the stand has been accused of being a hired gun by the other side. And even though juries have evolved over the years, and judges also know that an expert is the need, an expert is there to help the court system, to help them see beyond the technical aspects of the case. But do you feel that it truly makes a difference in your credibility when you are not working as an expert witness exclusively? Because there are many who primarily do expert witness work. So do you feel that it actually makes a difference? Or do you feel that this distinction is only on paper?
I think that it helps the jury to understand that I have interests that go beyond litigation. I am absolutely passionate about non-drug treatments for mental health issues, and I believe that I can make a contribution in that area that can potentially benefit everyone in the world, and that's just the passion. And I hope that being honest about that can show a jury that the expert witness part is not the only thing that I am spending my time on. So I don't think it makes a giant difference, but I feel like there is value in it.
Today's episode of On the Stand is brought to you by Xlightum, the AI-powered platform where attorneys find expert witnesses and experts grow their practice. Every week, hundreds of new experts join Xlightum, giving attorneys instant access to qualified witnesses without any finder's fee or markups. Need someone else to handle the vetting? Our concierge service does it all. You only pay when you retain an expert we present. So whether you are searching yourself or letting us do the heavy lifting, Xlightum makes expert discovery fast and smarter. Visit Xlightum, that's exlitem.com, to find your next expert witness today. And do you think your teaching experience at Illinois and then your role as the technology evangelist at Siemens, did that help you in eventually being able to explain technology to lay audiences better?
Absolutely. I loved it during my university teaching when, the folks who weren't engineers who had come to my bioengineering class because they were forced to take some hard science class, they told me that I had explained medical imaging in a way they could understand. That really was a joy for me. And when I was at Siemens, there was this innovation center where they brought their key opinion leaders, clinical people, folk who don't have a deep understanding of the way that medical imaging devices work. And so it was up to me to communicate to that audience why what we were doing in the development organization mattered. So it was all communication or a translation job. And I feel like that's exactly the same as what I do with the finder of fact, the judge or the jury.
Mm-hmm. And Dr. Daft, you worked at the ITC, you worked in district courts, you've worked in front of the PTAB. But I believe you mentioned that ITC trials are like producing an opera. So can you explain what makes these cases so demanding compared to district court or PTAB proceedings, and how are these different from an expert's perspective?
The ITC, there are a couple of ITC cases I have done which have gone all the way from the beginning. I was retained right at the beginning to the hearing, the trial. And so there are several aspects of that. There are a couple of technical things about how the patents are interpreted differently, but that's not a large factor. What is mainly making it different is the pace, because there's like 9 months from the instigation of the investigation until the trial. So all of the things like writing reports, and usually there's more than one report, depositions on each of the reports, and then preparing for the trial, that all happens much faster than a district court case. And then it's quite the performance once it gets to the ITC, because there are typically many witnesses who are flying in and they only have a certain amount of time. And so I was astonished the first time I did this to see how much choreographing that was done by the law firm. Everything had to be changed in real time so that there was a seamless experience, and there was never like dead time, because the other side and the ITC are counting the minutes. And if you did not have a witness ready to go, then you're losing your most precious resource, which is the time allocated to you. So the amount of organization and flexibility required to do that was really nothing that I had seen working in research labs. It was much more like perhaps producing an opera or something like that. It's not even like producing a movie where you can cut and you can try it again if things go wrong. There is no do-over in that trial.
Interesting. And you also ended up testifying in the first remote ITC trial during COVID. I believe it was the Philips versus Garmin case.
That's right.
So again, one, you just said that it's like an opera, there are no do-overs, and then COVID hit and it went online. What lessons from remote testimony did you learn? And are there any that should become permanent practice?
What actually happened in that trial was done at 3 places, or perhaps 4. There was the judge's house, which was one of the video locations. There was opposing counsel's office. I actually went to North Carolina, so I was in retaining counsel's office, and they had basically set up a small television studio for everyone to testify in. So it was not like, completely remote testimony. But there were also, as well as those 3 locations, I believe there were people in the ITC building, like the ITC staff. So that was a bit strange, but it worked out fine. The one thing that sticks in my memory is completely silly. Unfortunately, the judge had something wrong with her video setup. And so while I could hear her questions and commentary clearly, the video was distorted, and nobody wanted to tell her that there was something completely wrong with her video. So we were all trying hard to ignore that and trying to focus on the trial. So that was just a very strange experience. But in the end, I was able to give my testimony, and I was glad at the end when the judge's brief after that, she actually wrote that I had helped her understand the issues, and so when I saw that, I felt that I had got my job done properly.
Mhm. And most of the things that you would explain are, again, like super complex technology, like MEMS sensors or AI algorithms. So how do you make it understandable to a jury? I mean, I'm guessing you would try and explain it to them like you would to a high school student. But can you give me an example where you had to take a very complex concept and explain it in a very simple way to the judge? And has this ever happened that you're trying to explain it in a way that perhaps it's not connecting and then you had to change your explanation approach?
For sure, the way to approach that is to find analogies
Yeah.
that absolutely worked. Thinking back to that ITC trial, I knew that the judge had a technical degree, and so had doubtless done things like practical work at a university. So I didn't have to go the whole way to a really, really simple analogy. I guessed that she was familiar with things like oscilloscopes and recording data, the type of thing if you were a physics undergraduate you would do in the practical lab. And so I tailored my explanation to that, and that seemed to connect with her.
Mhm. And what about cross-examination? Again, I mean, these are high-stake cases with billions of dollars at stake. So I can imagine the opposing counsels can get a little aggressive. So how do you handle that, especially when they try to impeach you with your prior testimony or academic writings or by calling you a hired gun, like you said?
There's quite a lot of difference between cross-examination in a trial and in a deposition.
Hmm.
In a deposition, there are essentially no adults in the room. And
Yeah.
so they can ask basically anything with only a couple of things that are off limits. For example, were they to ask about my communication with retaining counsel, the retaining counsel will object and tell me not to answer. But if they want to ask about my income, if they want to ask about what proportion of your income is litigation related versus pure technical consulting, all of that, the retaining counsel may object, but I still have to answer it. Those are situations where I just realize that I don't need to sound intelligent and I don't need to win arguments about my personal life. And so I give a simple answer. They'll usually re-ask the question again and again, and eventually the retaining counsel will say, asked and answered, and then they usually move on. I find that it's just helpful to realize that this is the attorney playing the game that they have to play, and the part that I need to play is to not get rattled at all, not bother about whether questions about my personal life are inappropriate. That's not the game. The
Yeah.
game is that I am there to defend my technical opinions that I've expressed in my report, and everything else, I'll just, if it's a simple question, I'll give them a simple answer. If I don't know, I'll just tell them that I don't know.
Hmm. Yeah, I think they also try and do this when, one, obviously to try and rile you up, and secondly, when they don't have much to question you on your technical aspects of your testimony, that is when they also try to, like spend more time on your personal. In fact, earlier today, I was looking at a deposition, like a summon which an attorney was sending to the opposing expert, and they wanted the expert to bring all the income statements that the expert had made from expert witness work in the last 5 years. They wanted the expert to bring it for their deposition so that they could, review and question. So, yeah, I mean, that's, I think, a necessary evil of the profession. Let's talk a little about some of your landmark cases, and you have quite a few. Like we talked about the Phillips versus Garmin case earlier, which pretty much resulted in a complete victory for the side that retained you. Like
Yes.
no infringements, the patents were invalid, they were not patent eligible. So from an expert's perspective, what made the difference in achieving such a comprehensive win in a case like this?
That situation where I'm focused on invalidity
Mm-hmm.
is an interesting one because it gets painted in very theatrical terms at the trial.
Yeah.
Um, the plaintiff side will paint it as if the outcome is really obvious.
Mm-hmm.
And at the high level, if you listen to how they talk, it really sounds convincing. And so where I start, where they are cross-examining me, the die is kind of cast in a way that makes it very much look like the plaintiff has a very convincing case. And so I have to start with, well, it might look like that at a superficial level, but in fact, what matters for invalidity and to some extent non-infringement is details.
Mm-hmm.
And so I am here to show that while the big picture may sound very convincing, when you drill down into the details, the argument does not stand up. So that's a tack that I've had to take a lot of times. And so, yes, I end up undermining by providing technical detail in lots of different ways.
And you also worked on the Massimo versus True Variables trade secret case,
That's right.
where a former employee allegedly stole pulse oximetry technology. So, how do trade secret cases then differ from patent cases from an expert witness perspective?
I've done several trade secret cases, and one thing that is frustrating is to understand whether trade secret theft had happened or not. And that is just usually a very difficult thing to establish. I was retained by the plaintiff side in a trade secret case, and the retaining counsel did lots of discovery, very sophisticated e-discovery. And in the end, it seemed unclear to me exactly how much trade secret theft had taken place. Now, fortunately, it was not my wheelhouse to testify on that, but patent cases are rather clear cut because what could be prior art has a very specific definition, and questions of infringement and validity are also more clear cut. So while there's been legislation passed like the Defend Trade Secrets Act, I still feel like trade secret cases are just more fuzzy, and that makes them more difficult.
Mm-hmm. And tell us about the X-ray case where you worked on the technology that involved breast cancer diagnosis. I believe it's the X-ray tomosynthesis, the Hologic versus Fujifilm case.
Yeah, that's right. That one was very interesting because this is a technology that I've done a lot technically.
Hmm.
Breast cancer screening is a big political issue, but the facts, if you go to like the Cochrane studies, which are like meta-analyses of enormous amounts of research as to whether traditional mammography is actually effective or whether all it does is create enormous amounts of false positives that drive up the cost of medical care without making much of a difference to women's lives. So this technology, the tomosynthesis, is an attempt to get past the limitations of mammography where the false positives are just a crushing disadvantage of their technology. So I really liked working on that case. That was one where my arguments about invalidity and non-infringement were not ultimately accepted by the ITC. But it was a case where I really wanted there to be competition in the
Hmm.
industry. I felt like, aside from my view that the patents didn't have a lot of value, this was a technology where if it were more widely available to women, it could actually make a difference in the world.
Hmm. Yeah, I mean, I can understand when technology is directly impacting patient health outcomes. It can have a great weight on the expert as well. Uh, And talking about the plaintiff and defendant balance, that's something that experts are asked a lot. So you did say that you maintain a balance between your expert witness work and your technical work. But what's your split between plaintiff and defense work in IP litigation, trade secrets, and patent cases that you do?
I do keep a record of that because that's a question I get asked in deposition quite often. And it's 50-50.
Hmm.
And I think that it's important to not be seen as someone who has some view about the court system. In other words, maybe I don't want the cross-examining attorney to get anywhere with the idea that I have some personal view
Yeah.
about the patent system where that's coloring my opinions. And the patent system in the US at least is undergoing significant changes. Like if you look at what has happened to the PTAB in the past year, there have been quite a lot of decisions which have been classed by the USPTO head as precedential, and a lot of notices issued by the PTAB as to how they are going to deal with IPR submissions. So patent law is not a static thing.
Hmm.
And I want to make sure that there's no way that it could be alleged that I have some kind of bias or some kind of view about patent law. That's not me staying in my lane.
Hmm.
My job is to simply read the patents and give an opinion as to whether they are valid and what the prior art looks like with respect to them.
Which also then brings me to another phenomenon that we are seeing of late, which is the explosion in the NPE litigation, the non-practicing entity litigation. And you've been in this space for over a decade. And last year, I was reading somewhere the NPE litigation has surged more than 20% in the last quarter of 2024. So I don't have the latest data, but what do you think is driving this dramatic shift, and how is it changing, like how experts are involved in this space?
I think what is driving it is the economics. So,
Hmm.
for example, you see litigation funding companies which have been controversial in the past. And judges are having to give rulings as to whether those litigation funders are real parties in the case. And obviously, the law firm which is propagating the litigation doesn't particularly want to disclose that they have outside funding like venture capitalists behind them. And so I think what you're seeing is, at least in part, a result of changes in how the courts are viewing things like external litigation funding versus the client paying for the litigation or contingency fees. So that's kind of interesting for me to watch, but it doesn't often affect my opinions. Where it does affect is that quite often I get calls, particularly from the agencies, who tend to be contacted by NPEs, and often, or at least some percentage of the time, I will look at that and think, this is not a case I wish to be involved with, because this looks like patent trolling, and I am not interested in that.
Makes sense. But Dr. Daft, let's go to the segment on AI, and especially because you pioneered neural networks for ultrasound back in the 90s, and now you work with AI at Sunmai, and very few AI healthcare patents get granted. So where do you see one AI patent litigation heading, especially with there are a few cases that are pending at the Supreme Court right now? And secondly, how do you explain AI's black box problem to judges and juries?
I think this is a situation where one way or another, either through Congress acting or more likely through judge-made law, there has to be a change. There has to be a change in patent eligibility, and there has to be a change in the way that litigation around AI-generated patents takes place. So honestly, I think that's going to be a mess for a while until the system just is constrained to make decisions as to what is an AI's input to a patent. So I don't expect any clarity about that for a number of years. I don't think this gets solved in any short amount of time. The thing that is a very interesting situation for an expert witness like myself is the use of AI during the formulation of opinions and all of the protective orders that often need to be signed, and how that constrains the way that knowledge systems can be used for AI. And so I think this is perhaps an area where I can provide some value to other experts. So I'm giving a talk at a conference, I think it's in May of next year, on exactly that. So pitfalls for experts using AI, ways around them, and the best way to involve AI in your practice, because I think there's a lot there that in terms of best practices. So I'm actually developing a talk for that right now.
I think that's very timely because one, everybody wants to know how to use AI. Nobody wants to get caught using AI the wrong way. And yet at the same time, courts are grappling with new instances of attorneys using AI and filing hallucinated citations, experts using AI to write their reports and then filing hallucinated publications and other sources. So, yeah, I mean, I believe this is something that's very timely, that because AI is not going anywhere. So no matter how much experts keep saying that, oh, don't use AI, AI is not for experts. But I believe that if it's used the right way, will only benefit from AI. But yeah, you have to have the guardrails in place. So props to you for coming up with a talk on that. We'll definitely
I
highlight
mean,
the conference.
yeah,
Yeah.
I just completed a report in a biometric security case
Hmm.
where I had to cite to the academic literature maybe 30 times or something.
Yeah.
And I took very good care that each of those citations not only had a link to the paper, it noted the date where I had followed the link. And also, I pointed to where in the paper I was taking the information that was a basis for my opinions, because I'm sure that I'm going to be questioned closely as to the validity of my citations.
Mhm. No, I think citations are more than the experts writing them and the attorneys retaining them, is the opposing counsels who are researching the citations these days. So yes, I think you are doing the right thing there by just being double sure that all those citations are there. And even typos can get you in trouble these days.
Oh yes, I mean the judges are
Yeah.
just brutal, both to attorneys and to experts. If they ever have some hallucinated citation, there is no mercy for that. So this simply cannot ever happen.
Mhm.
And you have to put that in the context of when I am searching for literature that might support my opinion, of course I'm going to use an AI. That's not some kind of confidentiality thing, but it is absolutely on my shoulders
Yeah.
to make sure that anything I use is something that I have read, something that is accessible, something that I provide as a PDF to make absolutely sure that no one could ever claim that I have put a hallucinated citation in a report.
Yeah. So, um, you were talking about wearables, the wearables and the biometric security cases. So wearables now, again, I mean, this is something that I wanted to talk about, and it's a good segue to go there, that they sit at the intersection of consumer electronics and medical devices. Like, for example, the Apple Watch can now detect AFib. It can measure blood oxygen. There's this, like, I wear this Whoop that tracks my sleep. It tells me when I should go to sleep. And it also does things like SpO2 monitoring,
Yes,
and now the newer ones also manage, like record your blood pressure.
right.
And also, how do you navigate these blurred boundaries when you are testifying about, like, are these consumer electronics, are these medical devices, do you think courts are equipped to handle this convergence, or do we need
Well,
new frameworks?
this is definitely in my wheelhouse
Hmm.
to navigate how things go from medical devices to consumer electronics. And
Yeah.
so, Sanmai, the startup that I co-founded that you had mentioned, is actually exactly that. So,
Okay.
the first product is absolutely something that is to be used in a clinic by a doctor. And there are lots of reasons for that, but really it comes down to having someone very qualified actually making sure that the device is doing the right thing. But if you read Sanmai's patent applications, you will see very clearly that that is not the end goal. The value that Sanmai can provide to the world is to make a cheap wearable device that offers health and well-being benefits to anyone. And so that transition from the relatively expensive device that works in a clinic to something that has enough intelligence that it can be used by a completely uninformed member of the public, that is something that I have been working passionately on for a number of years. So that's a place where I also feel like I can help finders of fact, judges and juries understand what is at stake.
Let's talk a little about working with attorneys and case selection and red flags. So, can you point out a couple of red flags that when you see them, you're like, okay, no, this attorney is not for me. This case is not for me. One was
Yeah.
obviously you don't want to work on NPE cases, but generally, what about attorneys and law firms that, like, a few things that spook you?
Yes, well, certainly in PE cases, if the patents just seem like they're swinging,
Mm-hmm.
to hit some home run for their litigation funder, I'm not interested in those sorts of cases. Another type of case would be where there is some unusual time constraint, or a case where the expert has dropped out. And they won't always even tell you this. Maybe the expert has dropped out and there is now a time crunch. Those cases tend to be weak just inherently. And also, while I'm willing to work very hard, I have to, as an expert, have enough time to formulate opinions and research them so that I can discuss the basis for my opinions under very hostile interrogation. So a time limit, I'm not meaning, everyone knows that ITC cases work on an accelerated schedule, but some situation where there's worse than ITC time constraint would be a real red flag for me. And so I've turned down cases that fall into that bucket.
Yeah, I mean, as the saying goes, you don't rise to the occasion, you fall to the level of your preparation. So again,
Absolutely.
if you've had no time to prepare, that's not doing anyone any good, not neither to the attorney, nor to the client, and not to the expert.
And I really only have one resource which
Hmm.
I can offer, and that is my credibility.
Yeah.
So if my credibility is um, destroyed because I didn't prepare well enough, then I need to stop being an expert witness and find something else to do.
Yeah.
Credibility is the only currency I have. And so I have to be able to spend enough time to carefully formulate opinions, and before the deposition and before the trial, put the hours in so that I am able to fluently and fluidly explain why I have the views that I do.
Hmm. And on the flip side, have you seen the like real advantage of being retained early in the case, or even like brought in before the case has been filed?
Oh, yes. There are a couple of law firms who just seem to rise to the top. I really like it when they call me because it's as if they have a company culture that knows how to work with people like me. And like you say, it starts with being brought in very early, and it continues with having me involved a little bit in their theory of the case. That's a bit of a double-edged sword in that I totally understand that they may not want me to know the whole scope of the case. An example would be when one of the people involved in the case had done some bad things, and it can be useful in having me stay in my lane for me to not know about these things, because certain facts can have some influence whether no matter how hard you are trying to only give the technical opinion. But having said that, these law firms that have the corporate culture of real excellence in terms of working with experts, they often are able to bring me a bit more into their theory of the case. And with that, I can often suggest things that they might not have initially thought I could provide opinions for. So those people are really cool to work with. The other people who are cool to work with there are some lawyers I've worked with have got like PhDs in hard science as well as the doctorate in jurisprudence. It's like, how many decades did you spend on your education? It's just very impressive how learned some of these people are. And I do like working with folk whose focus is different from mine, but whose level of learning is just superb. It's a lot of fun understanding the concerns of a real professional with a fabulous education in a sphere which is completely different from mine. I just enjoy that difference, that diversity.
I couldn't agree more with you on that, because in a way, that's something that I do on every episode of this podcast, because every guest is a very learned professional, and I get to hear their perspective on how they navigate the whole attorney expert witness intersection. So, I couldn't agree more with you on that perspective that you brought here. Now, tell me, what are the biggest mistakes you see attorneys make when working with technical experts?
I remember being questioned about the fact that I had a subscription to the American Bar Association, which is, a lawyers organization, not really an experts organization, and the interrogating opposing counsel was trying to turn that into painting me as something that I wasn't. And he went on and on about it and wanted to know how much money I had paid for my ABA subscription and why I would pay that. And I just said incredibly simply, it gives me discounts on their books. And everyone, there were like 15 people at this deposition, and they all laughed. And the attorney then went on to a different tack. So, sometimes simple answers like that deflate very theatrical lines of questioning. I think the thing that is that I have to watch is when an attorney is pushing a line of argument further than my opinion can go. That's when I have to have an uncomfortable discussion and say, as far as I can see, the prior art and the literature don't support going that far. So I can testify to this. I know you're asking for a bit more than that, and I can't testify to that.
And what advice would you have for engineers or scientists who may be considering doing expert witness work?
Oh my goodness! Well, it's not as if I have done a whole lot of it. As you see, I've done, I don't know, maybe 15 or so depositions and 5 trials. So I don't feel like I'm an enormously seasoned person. But I would say that it is an interesting thing to get involved with if you like interacting with people whose skills are in very different areas. So it helps if you're something of a generalist. When I was at Siemens, I used to manage a lot of analog chip designers, and they are fantastic people with a depth of understanding that I will never have. But honestly, if you are as focused as those analog chip designers that I would manage at Siemens, it may be hard to become an expert witness because you may just get frustrated with interactions with people who don't have the specific knowledge that you do. Whereas if you're more of a generalist like myself, then expert witnessing can be a very enjoyable way of working.
Mm-hmm. And what do you do to handle potential conflicts? Because you also consult for companies, and then there may be cases involving their competitors that may come up. So how do you manage the whole conflict check scenarios? And have you ever had to turn down any cases due to conflict?
I have had to turn down cases for conflicts, but in those situations, it's rather clear cut.
Mm-hmm.
So there was a situation where I was, just involved in another case where I would be adverse to the potential case. The practice there is very simple. It's to disclose everything to the lawyer before I get retained, and then nobody will get upset, and they can make the decision as to whether this is a conflict that's a problem. Sometimes I'm not so sure, because sometimes it's a legal question. And sometimes it's just one of these theatrical points. So I remember being deposed about having done technical work for Fujifilm when I was then doing litigation work for Fujifilm. Every time I did a deposition and on the stand, I was asked about this. I explained that I was doing technical consulting for a completely different division of Fujifilm, and the technical consulting had ended several years before. I had no commercial relationship with Fujifilm and had not had for several years. So I just described what the history was, and the lawyer did not get anywhere with trying to establish that I had a conflict of interest.
Mm-hmm. Yeah. No, I mean, unfortunately, with some lawyers, what we have seen is they don't want to touch anyone with a 10-foot pole if there has been any association in the past. Like what you are explaining makes perfect sense. I mean, it was a different division, it was several years ago, there's no way you are biased. But I think those are the realities of the case, and you just have to hope that lawyers who are retaining you see the value that you bring and don't get sidetracked by like something that you may have done decades ago or years ago.
Yeah, I mean, there have been times when I have not been able to testify in cases where it did not seem to me that there was a conflict of interest because of, like what you said, my technical work was a long time ago. But there are certain parties where if you have ever taken the other side to them, you are blackballed forever. And there you just have to make a decision as to whether it's worth taking the case, because you know that you're not going to be allowed into other cases. I mean, there's one which I won't name that is absolutely famous for that situation. And it's just a question of, do you take this case because you know that you won't ever be retained by that party's counsel if you take the case?
And that brings me to another thing that it's hotly debated in the expert community, and that is thought leadership. So some experts believe that, you should not write anything in the public domain, don't publish any blogs or articles, don't have a website, don't go on podcasts. So I know which camp you are in, because you're recording the podcast right now. But you also maintain an active publication record. You
Yes.
have several IEEE papers, you have blog posts, you have recent neuroscience publications. So how does thought leadership contribute to your practice, and have publications ever come back to haunt you in cross-examination?
Lawyers absolutely bring up publications that I have done in the past. One example of publications is for Sanmai, this startup that you mentioned at the beginning of
Mm-hmm.
the podcast. Um, that company has filed 5 patent applications now, and many of these have now been published. And so in my last deposition, several of these were put in front of me and I was questioned on them. And that doesn't trouble me at all if the attorney wants me to explain what my patent was. I can spend the whole deposition doing that because that's very easy for me. But somehow, even putting that kind of material in front of me um, is part of them trying to frighten me or something. I mean, I don't really know why they would think this would upset me. I mean, it's public information. I also find that when judges have written opinions and rulings where they talk about my opinions in them, that stuff gets put in front of me at depositions, and the attorney's always trying to make this sound like I'm this charlatan who has provided frivolous opinions, and there's nothing to do in that situation except listen very carefully for what they are asking and answer that specific question and then stop talking.
I think judges, when they are giving a review for an expert in an opinion, one, it's part of the public domain, and it's not that those comments will always be critical. They'll also be great comments. So, do
Yes.
you then try and keep a track of what public documents written by judges say about you? Because again, ITC, PTAB, US, the federal district court in Texas, where all these patent cases happen, all those documents pretty much end up in the public domain, especially the orders written by the judge. Yeah. So, do you track these orders where they have named you and they've talked about how you did as an expert, or any
That's
commentary that
actually
they made?
something that I should probably pay more attention to. I definitely remember it when judges have said nice things in their rulings about how I have been able to explain the technical issues. I have also found that law firms have cold called me because they have gone to LexisNexis and looked me up, or maybe they don't know my name, but they've looked up rulings, and so they've told me this is how we found you, because this judge said this. So
Yeah.
this is definitely something that I should perhaps pay more attention to. My problem is LexisNexis subscription is very expensive.
No, but I mean, you can actually, like USPTO, every document that is filed in the PTAB, it's
That's
available for free on their website, and you can search. And in fact, that is how we build our database of experts, where we go into court filings and we look at, okay, which cases, which experts are being disclosed of late in all these different kinds of cases. And
interesting.
that becomes a great way to find experts. So I'm glad that attorneys are doing that, because rather than just running a search on the internet, or again, I mean, those are great places. You can go to a directory, you can go to a referral agency. But if you can find somebody who has worked on a similar case and has favorable commentary from a judge, then I think that's a great expert to pick. And that's
Yeah.
pretty much our primary MO as well. So, again, like, great props there. What do you think is the future of expert witnessing, especially with AI and automation? You told me that you're preparing a talk, and even though it's going to be in May, can you give us a few points around that today?
For the near future,
Mm-hmm.
I think that the advent of AI is going to be highly beneficial for experts because it's knowledge work, but it's knowledge work where the personal touch is appreciated and also required by the system. And so I feel like there'll be a good while when advent of AI is only a bonus for those experts who can use it well as a tool.
Mm-hmm.
My personal opinion, and this is not an expert opinion at all, is that humanity are facing over the next 2 to 4 years a rather unstable period where a lot of things are likely to be shaken, which have been rather stable for a lot of time before. So the long-term future of expert witnessing is not something that I have any clarity about. But I think that for the next few years, it will be a boon that as an expert, I can make good and also compliant in a non-disclosure sense use of AI.
Mm-hmm. And do you feel AI can maybe if not completely, but to some extent, replace what experts do today?
I think this will technically be possible soon,
Mm-hmm.
but human systems move much slower than technical aptitude. I noticed yesterday that there is a bet that has been published by a guy who works for Google DeepMind. There is a long standing mathematical issue about the Navier-Stokes equation, which is basically the whole of fluid mechanics, how heart valves work, how airplane wings work. And this man has made this bet that by the end of the year, he will publish a proof with a solution of the Navier-Stokes equation or an aspect of that equation that has been hanging out there for 150 years. The Clay Mathematical Institute has $1 million prize that they have offered for many years. Humans can't solve this, and this guy must be very close. And he works for DeepMind, so he has got a lot of tensor processing units.
Yeah.
That's the world that we're in. Humans have been wanting to know the solution to this. Is a major piece of mathematics.
Yeah.
What happens after mathematics is solved? Do you then solve physics? This is what I hope will happen. Mathematics and then physics and then chemistry and then biology and then medicine. And there we will start really providing benefit to humanity. But I think this has something to say about whether, from a purely technical perspective, the function of an expert witness could be done by an AI. That said, we work in a human system, and I do not believe that will change for a good number of years.
Yeah. Yeah, I think I remember seeing like almost a month ago that after GPT-5 was unveiled, somebody decided to tackle an open math problem. And I think...
Yes, there are many. So there was this mathematician called Erdos, who basically, I think he lived maybe in the first half of the 20th century. He went around collecting unsolved problems. And so there's a website called Erdos Problems. And in that, you can see his accumulation. I think there are several hundred of these. These are somewhat abstruse mathematical proofs. And GPT 5.2 thinking has been knocking these off. It has solved, I think, maybe a dozen is provided proofs. The proof did not exist, or it was in some paper that no one knew about, and it just searched and searched and eventually found this obscure paper, and so now the whole world has it. Those are small wins. I feel like this Navier-Stokes equation issue is a step function. It's a 0 to 1, because that is a serious piece of mathematical research which we, humanity, have been unable to address. If that falls, then these dominoes of AI becoming superhuman in mathematics will be a lot more credible.
So what's your one key advice to experts today who maybe are not very savvy with AI and their only AI compatibility or education is that they know how to go to ChatGPT and ask a question?
Right. The way I would start is simple: to use AI kind of extravagantly. In other words, don't just go to it when you have a problem which you know that it will provide some value. Continuously refer to it, because one thing leads to another, and the path will just sort of illuminate itself as you get deeper into it. But I would just start with spend more and more time with the AI as almost a coach. And I found that has had enormous value. Last night, I was trying to plan what I was going to do over the Christmas period. And I've got like 5 really valuable projects that I need to get done, which I would not have even started on were it not for playing around with AI. And that led to vibe coding things. I mean, I've written a lot of software in my time, but I can write software 10 times as fast as I used to. And in areas which I am not familiar with. The chatting to the AI led to vibe coding, led to, I now have this system which is so exciting that I even want to quit my day job and just work on this because it's that interesting. So that's what I would recommend for an expert. Just put in the time, ask many more questions than you would naturally do, and the ideas will just come up.
Yeah. No, I mean, I totally agree. I think the more curious you can be, and I think we are pretty much limited by our own imagination today as to what can be done using AI. And you gotta, I think you need to put your hesitation aside, get spend that $20. I mean, I think you should one should get a subscription to 2-3 different AI models, ChatGPT, Claude, Gemini, because they all have their own different capabilities.
That's
See
right.
which one works best for you, and just spend time. Yeah, I mean that is probably the way to go. So I'm really looking forward to the talk that you are preparing, and maybe once you have presented it, we'll bring you back on the show and talk more about I'm sure things would have changed exponentially and
Well,
dramatically between now and
that's the thing. So I started. I kind of knew this was going to be a talk that was always in motion. So I started getting slides together just after I was invited to give this this talk. Which I think is in May. I can send you the link about it if you want to put that in the
we'll
show
put in the
notes.
show notes. Yeah.
Yeah, but I started developing these slides and I realized that several of the topics are just going to be completely in flux. And it's a long time between now and May. So I actually am hoping to present it to a couple of the local law organizations for continuing legal education. But I know the talk I'm going to give in February is not the same as the one in May. So these are just, it's rather different from doing a technical talk where the material is a bit more static. So yes, I'm just sort of continuously working on these slides, and so hopefully I can keep them up to date all the way until when I actually have to give the talk.
Even with our own platform, like we are now using AI for expert discovery, but as we begin implementing AI into the different aspects and we are loading up more data and asking more questions, we see how, again, it's all changing. We can see there are more things that can be done. What are a couple of things that you would want, like AI, to help with the attorney expert witness intersection, where attorneys work with experts? Do you have any thoughts on that?
Yes, I mean, one of them is purely technical. I spend rather a lot of money on local processing. As in, I have a PC here, a desktop PC with a large GPU in it. And those things are expensive, but with those, I can use that as a thinking assistant without any concerns of, having to navigate court orders. So I am really looking forward to the advent of on-premise AI that has more capabilities than what I can do today. And so NVIDIA recently produced a little desktop thing. It looks like a Mac Mini.
Yeah.
And it's got a Blackwell chip in it. And I was looking at that, actually decided not to purchase that, but devices like that I am very interested in incorporating into my practice purely as a way of making sure that I'm always providing the best possible level of confidentiality to my client.
That was really useful, Dr. Daft. Anything else that you wanted to talk about that I have missed in my outline in my questions?
Well, I just think that the next few years are going to be fantastic for experts because of this, it being such detailed knowledge work. And if the AI systems can be used in a way that's compliant and powerful, it's going to be a very rewarding kind of period. And after that, who knows what's going to happen? But I think we're in for a really interesting ride over the next few years in the expert witnessing world.
This has been an incredible conversation, and your perspectives bridging active innovation with expert testimony. It provides invaluable insights, like, to me and to everyone who's been listening. Where can people find you if they want to reach out to you about your expert work or the other work that you're doing with Sanmai?
Sure. The website is riversonicsolutions.com. And that's the easiest way to see what I do. Mm-hmm. Like you said, all of my publications are there. And actually, you can find out a lot about, if you just go to the Patent Office website and search on my last name, which is an unusual last name, D-A-F-T, you'll be able to see what I've been working on with Sanmai. So I'm easy to find in that regard.
We'll add all those URLs in the show notes, and so that users don't have a difficult time finding you. Even though River Sonic Solutions, it's very easy to remember. So thank you once again for joining us on the stand, and thank you to our listeners. And I really hope to get you back again after your talk in May.
Well, Ashish, it's been an absolute pleasure. I have very much enjoyed talking with you, and yeah, let's do this again.
If you found this podcast useful, remember to subscribe and give us a review on Spotify, Apple Podcast, YouTube, or wherever you listen to podcasts. This will help other users find this podcast and benefit from the insights shared by our guests. If you'd like to be featured as a guest on this show, please write to media@xlightum.com. See you in the next episode.